Yes, hello and welcome to the class today. So today we are going to look at a new subtopic under the topic of law of torts. And today we are going to concentrate on what we call trespass as a tort. We are going to concentrate on trespass as a tort, or as a tort or a wrong that can actually be committed by a person. So trespass can actually be categorized into three. So you can have three classifications under trespass. So you can have trespass. You can have trespass to land. We can have trespass to persons. Then we can have trespass to goods. Trespass to goods. So these are the three categorizations we can have with regard to trespass. So when we talk about trespass, it is simply the unauthorized entry into someone's property, or basically unauthorized entry into someone's goods as a property, or unauthorized entry, for example, to commit what we call being able to maybe so we can talk about, in this case, when we talk about trespass to persons, we can have what we call battery, or something called imprisonment. So these are the classifications of trespass. So when we talk about trespass to land, it occurs when a person, actually whenever a person's possession in land is actually wrongfully interfered with. So when a person's possession of land is actually wrongfully interfered with, then we say that other person, who is actually the defendant, has actually committed what we call trespass to land. So in this case, we mean the unauthorized access, or the unauthorized means of making a person not to be able to possess his property in terms of land would be termed as being trespass to land. So it can actually happen by simply a person wrongfully entering, for example, the plaintiff's land, so entering the plaintiff's land, or remaining on the land without any authority. So, for example, if you enter a person's premise, or basically you enter a person's land without his authority, we can be able to say you've been able to trespass on his land. At the same time, if a person remains on that particular land, for example, if he had hired it or basically leased it and remains on the land for a continued period without any authority, so in such a case, the person will actually be accused of having committed what we call trespass to land. So other ways, for example, placing things or placing items without any authority on a person's land. So for example, if they're your assets, you basically place them on another person's land, or their properties or belongings, you place them on another person's land without his or her authority. In such a case, we can actually be able to say also, you have actually been able to commit what we call trespass to land. So in this case, we've said it is simply the unauthorized entry into another person's land, or basically interference with the possession of the plaintiff's or the complainant's enjoyment of his or her land. In such a case, we say the person has been able to commit what we call trespass to land. So you said it can happen by simply basically entering the land without authority, remaining on the land without any form of authority. For example, if you had leased it and you still actually continue to stay on the land without any authorization, in such a case, we can actually be able to say also we've been able to commit what we call trespass to land. So it can also happen whereby you are placing things on the land without any form of authorization or being allowed by the owner of the land, So what are the defenses? For example, if a person has been accused of trespass to land. So remember, as I told you, under the law of torts, you just need to be able to define the torts, be able to understand the torts, and then actually, of course, be able to give the forms of defenses. And also, for example, the remedies the court can actually be able to give as a relief to the plaintiff. So some of the defenses that can actually be put forward, some of the defense that can be put forward is number one, prescription. Number two, act of necessity. Act of necessity. So you can talk about prescription or act of necessity. So you can use that as a form of defense. Also, we can be able to talk about entry by license. So entering a person's land through actually being authorized. Entry by license, or a licensed person can be able to enter your land or premises without any form of authority. So you can use that as a form of defense in case he is accused of having done what we call trespass to land. So another one that is actually very common we come across under the other torts is what we call statutory authority. Statutory authority. So when you talk about prescription, so these were basically the previous owner to this particular action can be brought by the previous owner to recover the land. So the defendant may also plead prescription as by proving a right of common grazing or a right of way over the plaintiff's land. So if basically this has actually been a norm that a person basically has been enjoying the possession of another person's land without having been evicted, without actually having been questioned for a number of years or for quite some time, we can be able to presume that this particular trespass has actually been allowed or basically has actually been approved by what we call prescription. So if you are gotten used to basically passing through a person's land by being able to pass and actually basically maybe access another property without having been questioned for a very long period of time, we can be able to presume that by prescription, you've actually been able to do what we call, trespass. And in this case, you can use that as a form of protection. Act of necessity. So sometimes maybe you entered a person's land out of necessity. Maybe there was a disaster like fire, so you had to basically be forced to enter the land so that you can actually be able to safeguard or secure your neighbor. So if he accuses you of trespass, you can be able to plead that as a form of defense. Statutory authority. So simply whereby, for example, in this case, that particular access to a person's land has actually been allowed by a court of law. So there's a court order giving maybe the police the right to access a person's land. Entry by license. So certain parties might be authorized by a particular statute to be able to access maybe the land or properties of a person. In this case, we can give an example of, for example, an officer from the Kenya Power and Lighting Company has actually been licensed to be able to visit the premises or the land of any person and actually be able to access the meter box and be able to do what we call reading of the meter. So through license, this officer is actually able to access this particular property. So so those are the ways in which basically a person can actually be able to defend himself. A person can actually be able to defend himself. So what are the remedies the court will give, or the forms of reliefs the court can actually be able to give? So number one, they can actually be able to give what we call damages. So the remedies given by the court under trespass on land, so we can have, number one, we can actually be able to have what we call damages. So you can have damages. Number two, we can have what we call ejection. You can have what we call ejection. Then we can have injunction. Or number four, we can have action for recovery of land. Action for recovery of land. So those are some of the forms of defenses that can be put forward, or basically the remedies that the court can be able to issue in case a person has been accused of what we call trespass to land. So number one, you've said damages, so basically pay for all the compensation, or basically pay compensation or compensate the plaintiff for any losses incurred as a result of that particular trespass. Then ejection, so if a person has continued to stay on the premises or the land of a person without any authority, the court can actually be able to eject such a person, give out a court order to eject that particular person. So give out a court order to eject that particular person. Then you have injunction. Injunction is simply whereby the court gives an injunction order to stop a person from continuing to basically trespass or maybe access a person's land. So through the injunction, the court are giving that particular injunction order, the person will have no right to be able to access another person's land. Then we are saying action for recovery of the land. For example, if the possession has been taken up by another person, so the court can allow for action or bring of a case by the plaintiff or the complainant to be able to recover the land back into his possession. So those are the remedies that can actually be given by the court, or forms of relief that can be given by the court to the plaintiff in case there is a case that has been brought in terms of what we call trespass to land. So we've said number two, another form of trespass is what we call trespass to persons. So under trespass to persons, we can have what we call assault. We can have what we call assault. So under trespass to persons, we can have number one, what we call assault. Number two, we can have what we call battery. And we can have what we call false imprisonment. So just as I had mentioned, imprisonment, it is known as false imprisonment. So when you talk about assault, it's simply basically instilling threats in a person's mind. So threatening a person by instilling threats into his mind that maybe you instill threat that you'll be able to hit him or maybe injure him. So long as it is seen that it's like you are instilling threats, and of course there is what we call body contact, then you can be accused of what we call assault. So if you go ahead and basically cause an injury or harm to this person, you are instilling threats, or basically you are instilling fear, then we say you've actually committed what we call battery. So simply by just instilling threats or basically instilling fear, you'll be accused under what we call assault. But if you go ahead and actually basically instill injury or basically cause injury out of basically that assault, so it will actually no longer be an assault, but it will actually basically now be what we call battery. Then what we mean by false imprisonment, it is simply confining the movement of a person. So for example, locking a person in a room such that he loses his right of movement. So if you do such, then it can be concluded that you've actually been able to commit what we call false imprisonment, confining a person to limit his or her movements. So maybe it could be in an open place by pointing a gun on him or her. It could be in a room that is actually locked. In such a case, the person can be able to accuse you of what we call false imprisonment, or what we call false imprisonment. So those are the three categorizations of what we are calling trespass to persons. So maybe I'll share something here. So this trespass, just like other trespass to goods, also occurs in three ways. So you can have assault, battery, then of course you can have what we call false imprisonment. So what is assault? It occurs when a person intentionally threatens to use force against another person without lawful justification. The person in fear, e.g., putting the person in fear, e.g., pointing a gun towards him. What are the rules of this tort? There must be some apprehension or contact. There must be a means of carrying out the threat by the defendant. The tort is actionable per se, or basically the way it actually appears, so that there's no any actually form of proof of evidence to be provided. The tort is generally associated with battery. It's almost related to battery, but they are a bit different. Mere words without body movements do not actually constitute what we call assault. It is constituted by a display of show of force, pointing a loaded gun, or for example, cursing in a threatening manner. So what is battery? So this is the actual use of force towards another person without lawful justification, e.g., hitting a person. So remember, as we've said, under assault, basically it's just instilling fear or maybe threats, maybe through pointing of a gun. But in this case, you don't actually use force towards the person, or you cause the injury. So they are given an example there, e.g., hitting a person. It is also actionable if it is voluntary or intentional. So what is the meaning of intentional there? What do they mean by intention? Assault is committed where the plaintiff apprehends the commission of a battery on another person. If the defendant does not intend to commit battery, but induced a belief in the plaintiff's mind that he is about to do so, he is nevertheless liable under what we call assault. So by instilling fear, you'll just be accused under assault. But if you go ahead and actually basically cause an injury or do what we call apprehension of the other party, then in that case, you'll be accused of what we call battery. So that is the difference between what you are calling assault and battery. So under assault, it is simply just instilling fear. Under battery, there's body contact. And of course, in this case, the person maybe leads to an injury or causes an injury on the other party. So what is apprehension? So suppose the plaintiff is an unusually fearful person in whom the defendant can induce the fear of an imminent battery through a reasonable man would not have fear. In those circumstances, does the defendant commit assault? The better view is that the test is based upon the subjective intention of both parties, and there is battery if the defendant intends to create fear of commission of battery, whether or not he knows the plaintiff to be fearful person and the plaintiff actually has this particular fear. So that's what we mean by assault and actually battery. So what are the rules of battery? So absence of the plaintiff's consent. So if there's actually no any form of consent by the plaintiff, then battery will be pleaded as an action before the court. The act is based on an act of the defendant. Mere obstruction is not battery. A contact caused by an accident over which the defendant has no control is not battery. There must be contact with the person of the plaintiff. It has been observed the least touching of another person in anger is actually battery. Battery must be direct, and the conduct must follow from the defendant's act. The tort is actionable the way it actually appears. There's no need to actually maybe for prove, or there's no essence of basically having to prove. So what is false imprisonment? So the last classification under what you are calling trespass to person. So remember, we've said they are categorized into three. So you can have assault, you can have what we call a battery, and you can have false imprisonment. So this one normally actually occurs when a person is deprived their freedom without legal explanation. So if a person is deprived his freedom of movement, so freedom of movement, then in such a case, the person can bring an action in a court of law known as false imprisonment. So what are the main contents or main ingredients of this particular tort? So knowledge of the plaintiff, so knowledge of the restaurant is not necessary, but may affect the quantum of damages. So you don't have to prove that the plaintiff doesn't have to prove that he had knowledge that is actually being confined or his freedom of movement was actually being confined. Even without his knowledge, he can be able to bring the action of false imprisonment. So there's a case law there trying to explain. The plaintiff was being questioned at the defendant's company in connection with a certain thefts from the defendant's company. He did not know of the presence of two police who work outside the room who would have prevented his leaving if necessary. It was held the defendant was liable for false imprisonment. So this was the ruling of the judge. So it appears to me that a person can be imprisoned without his knowing. I think a person can be imprisoned while he is asleep or in a state of drunkenness, while unconscious, or while he is a lunatic. Of course, the damages might be diminished and will be affected by the question whether it was conscious or not. So the intention should actually be very direct. So the tort is defined to exclude negligent imprisonment of another person. The tort must be intentional and should be committed directly. The restraint must actually be very complete. So that particular movement must have been restrained completely, such that in this case, the plaintiff has any freedom of movement. So for example, in this case, if the door is actually locked and the windows are actually open, so this means that the plaintiff can still jump over the window and go outside. So he's not actually fully restrained. So unless maybe the windows are actually also closed and there is no any other form of exit, it simply means that in such a case now he can be able to plead before the court for what we call false imprisonment. So the restraint should actually be very complete. It should actually be very complete. So what are the defenses? What are the defenses under false imprisonment? So you can have parental authority. So the parents are actually allowed to confine their children from any danger. So they cannot actually be accused of what we call false imprisonment. So if you are fully confined by your parent, he fully knows maybe you have not attained the age of majority, and therefore you cannot actually be allowed to walk out anyhow. So he might confine you to the house. Judicial authority. So maybe there could be a court order that has basically been given that no one should actually step out of his house or maybe compound due to certain investigations which are being carried out by the court. In such a case, now the judicial authority will lead to what we are calling false imprisonment. So that's such that it can be argued the false imprisonment was as a result of judicial authority. So what are the remedies? So the remedies basically is to pay for all the damages incurred under the period which that person was actually put under false imprisonment. So maybe missed a business deal out of the false imprisonment. So you can be able to sue or ask for all the damages. We have habeas corpus. So habeas corpus simply means to produce someone whether alive or dead. So if a person is not actually able to be traced and they suspect that there is someone who knows where he is, they can give out an order. The court can give out an order, what we call habeas corpus. So the writ of habeas corpus is a remedy to false imprisonment. The writ directs the person in show or in the custody, or the person in the custody of the applicant is detained to produce him before the High Court. The court may order his release if it appears that there is not sufficient grounds for detaining him. So that's what we mean by the tort of trespass with regard to persons. So you've said it can be categorized into three. So you've said assault, battery, or false imprisonment. Then you have the last form of trespass. So it is known as trespass to goods. Trespass to goods. So this is simply whereby the owners of goods basically are actually allowed to withhold or maybe hold the goods of another person basically if they are not actually allowed, so sometimes they could actually be allowed, but if they have what we call unauthorized access, unauthorized. If a person has unauthorized access to another person's goods, whether in transit or maybe at the premises or final premises of the owner can be able to accuse him of what we call trespass to goods. So owners of goods are entitled to enjoy their possession and control their use without any interference. To protect goods, the common law developed 3 torts, namely detinue, trespass to goods, and conversion. So what is detinue? So this is the unlawful detention of goods. It is the oldest tort relating to protection of the chattels. Chattel simply means goods and protects possession of goods by the owner. The plaintiff must prove the right to immediate possession. The defendant detained the goods after the plaintiff demanded their return. Then you have direct trespass. So this is the intentional or negligent interference of the goods in possession of the plaintiff. This tort protects a party's interest in goods with regard to retention of their physical condition and invariability. Then the last one you have there is conversion. So this is the intention of dealing with the goods or converting the goods of another person into another form without his or her authority. So it protects a person's interest in dominion or control of the goods. The plaintiff must have possession or the right to immediate possession. However, a bailee of goods can sue third parties. In conversion, so can a licensee or a holder of lien or a finder. Any goods or chattel can be the subject matter of conversion. So there must be physical contact resulting in the interference with the goods. What are some of the acts that can basically be concluded as basically conversion of goods? So taking goods or disposing, destroying or altering, using a person's goods without his consent, receiving the voluntary receipt of another person's goods without his consent. Then, so that is basically what we mean by trespass to goods, and that is basically how conversion of goods can actually happen. So you're saying either taking possession of goods without another person authorizing, changing them into any form without the authority of the owner, without the authority of the owner, authority of the owner. So that is basically what we mean by the tort of trespass, the tort of trespass. So the tort of trespass.